Hello, my name is Jeff Straub. This is Two-Way Self-Defense Law. What we do is we try to help people understand the law of self-defense in the simplest terms possible. What we do is we break it down to the information that will give you the greatest effect, where you don't have to be your own lawyer, but you know more than most lawyers on how to defend yourself in self-defense law. If you've seen my YouTube page right here, I'm about to break 5,000. This is a long time coming. I've actually done Castle Tutelage 2A Self-Defense Law now since I believe it was 2012. Just my style, my personality, I think really hampers me. And what I haven't been able to overcome with YouTube is the way they do search engine stuff now. I am, for every 100 or so videos that I get on YouTube, I'm doing about 1,700 views on Facebook. I am seriously considering in canceling YouTube as far as 2A Self-Defense Law on YouTube and concentrate more on Facebook, because it seems like it is helping more people out on Facebook. I think I only have maybe 100 or so followers on Facebook, but I'm getting many more views. YouTube has been a serious disappointment now for about a year and a half, coming up to 2 years, I believe, in October, where they really have just gutted anything to do with self-defense law, with guns, etc. You guys know the drill. I'm not getting the views like I once have. I am not getting comments like I once have on YouTube. I used to get about 30 comments a day. I may get 3 comments a week now. And that's if I'm lucky. I'm only getting, at one point I was doing about $130 a month, and now I'm right around $13 to $18 a month. I do have expenses, books, classes, travel, etc. It's just not doing it for me anymore, so I am probably going to be canceling the YouTube account. If you still want to be following me, go over to 2A Self-Defense Law in the Facebook group, and we will go from there. Now, I am a big thing of narrative, and people have always told me, and my mentor has also said this, that they think that some people are concentrating too much on narrative. I haven't really gone into narrative. You need to have a little breadcrumbs of reasonable perception of your breadcrumbs, okay? If you have a reasonable person standard in your narrative has to have some kind of data points. And I've been getting criticized with that. Oh, all you need to have a narrative, you'll be okay. Well, my alternative is you not to have a narrative, or you not to have some kind of a plan that will help you out. The perfect example is in Minneapolis. There was a shooting of an unarmed man with the Minneapolis PD. How it got started right around, well, I don't want to get into that. It was 2 years ago. If you remember, about 2 years ago, everybody was hitting the police for any kind of a scenario. What happened was they found physical evidence to corroborate the police's storyline, the storyline of the narrative, that also corroborated with the ambulance video. What happened was a woman was being beat up by a significant other. The cops came. The ambulance was locked inside their ambulance for about 15 minutes while this guy tried to beat down the ambulance door. The police got there. They got in a tuffle. Police was on the ground. The guy, the narrative was the guy went after his gun, and the cop shot him. Okay, how did that narrative of the police paint true? Well, the video showed that the fight went to the ground, and when the officer got up, he had to spin his gun belt about 90 degrees to get it corrected, and they also found DNA evidence of the suspect's DNA on the officer's gun. That's how you corroborate evidence, okay? But for me, if you keep your narrative true and you keep it on the legal side of things, hopefully there are going to be enough facts after the fact that will corroborate your narrative. With that being said, everything is the hardest thing that I have with the law. There isn't equal protection under the law. And this is what I'm going to get into. If you remember, I talked about this this case a long time ago, the Commonwealth versus Storms. This is a guy who was in a church. A belligerent man came in, sat down in some chairs. An usher said, please don't sit here, can you sit over here? The man became belligerent. Started, getting into a verbal altercation with people, and then more people started surrounding him. The priest says, back off. He calmed down. This Storms character, again, he's under 5'7", comes over to him. He didn't like what was going on. He asked the person to leave. The guy became belligerent. He showed him his concealed carry weapons badge. The guy laughed at him and said that was fake. Storms got irritated again. 3, 2, 1. He lifted his shirt to show his pistol, and the belligerent guy punched him. To me, that was self-defense. Even though that the belligerent guy started with ordinary force being verbally abusive, he didn't touch anybody. He wasn't aggressive toward anybody. But as soon as someone shows that gun, hey, to me, that's deadly force. Now, this has already gone through the appellate court decision. Pennsylvania is a stand your ground state. For you people who say, I'm in a stand your ground state, I don't have to do anything. Sorry. Some states you literally have a flow chart where you have to stand your ground. And Pennsylvania, not uncommon like other states, has 3 requirements for you to hoops for you to jump through, for you to have a stand your ground where you don't have to explain your duty to retreat. The third one, and this is a little bit odd, this is a little bit different from the other states, but the third requirement of that is that you have to be attacked by a deadly weapon. I'm not going to get into what is deadly weapon and what states and what isn't, but this guy was unarmed. So what happened was this. This was the defense. The belligerent man, again, the other guy was 5 foot nothing, okay, under 5'7". His defense, and this is not uncommon as a defense, that he was bigger, stronger, faster, younger than Mr. Storms, and if he was allowed to get to his gun, he could have taken the gun from Storms' hand, and then the congregation would be there. And that's why he shot him, and that's why he didn't have a duty to retreat. Well, guess what? A lot of the parishioners that took the wisdom stand said, yeah, he had a clear path to retreat. All he had to do was go down the aisle and nothing would have happened. All right? Guess what? It was affirmed. He's in jail for 20 years. All right? If you want to go read the story, I think it is a fascinating read. I think for you people who want to learn a little bit more of the jump requirement, the hoops that you need to jump through for a duty to retreat or stand your ground, I think it's a fascinating thing. Okay, let's go here to Minnesota. I'm in Minnesota. Minnesota is a duty to retreat state. Okay, we don't have any hoops to jump through to prove that we didn't have a duty to retreat. We have a duty to retreat. Okay, and in this case has just gone through trial. I don't have all the facts in this, and I can only go by what was stated in the newspaper. This was an argument between neighbors. A neighbor gave permission to a group of people to go to a lakeside property. What happened was these people parked on neighbor's lawn. Neighbor didn't like it too much. He called his neighbor while he was working. The guy came over to where the commotion was, and he was in his car, and a guy in his neighbor who was in his 60s got off of something and started yelling at him, going toward him in a vehicle. The person in the vehicle was younger, or he was in his 40s, plus he was in his vehicle. What he did was, he feared for his life, took out the gun, shot the old guy in the heart, dead. Minnesota went to trial saying that he had a duty to retreat, and he could have retreated because he was in his vehicle while the other person was not. Well, the defense attorney hired a self-defense instructor, if you will, and he explained in a moment's notice, the guy could have gotten the gun away from the person in the car in a moment's notice and shot other people. The jury found him innocent. Or I should say the jury found him not guilty because of that logic. So I want to make it clear with your narrative, what we're talking about, your narrative may work in one area, but not in another. And I want to specifically point this out. These two cases are very similar, but the case in Minnesota where the guy was acquitted was younger and inside a car, while the other guy, the older gentleman, was outside the car. Where was the immediate threat of death or great bodily harm? Because he could potentially take a firearm that you introduced into the situation? Is that going to be your narrative? Are those going to be your breadcrumbs when you are talking to the prosecutor, when you are talking to those 12 jurors who probably, most likely, have never been in an incident that like you have, are going to be judging you? And again, Chicago County in Minnesota is in the northeast suburbs of St. Paul. It's about 20 miles north, 35 miles north of St. Paul. So we're getting to that a little bit more of a rural area. So I don't know if that is a component of it. Take a quick look and see the similarities between these two. You may, even in stand your ground states, if it is a legal statute, more than likely or not, you are going to have legal hoops to jump through for your stand your ground. Other states like California, where it is case law, you don't have those hoops to jump through for your stand your ground case. Again, I'd like to thank a lot of people who, the 5,000 for, or coming up to 5,000 for a subscription with YouTube. If you want to continue follow me, go to Facebook. I know I'm going to stay there, but I am not positive if I'm going to stay on the YouTube platform anymore. It may just take too much extra time. Where I'm getting 1,700 views on Facebook per video compared to 160-ish on YouTube. All right. My name is Jeff. This is 2A Self-Defense Law. I really hope this helped. Thank you.